Hello, and thank you for joining. My name is Rachael Parker, and I'm an associate at CM Murray, and I'm joined today by my excellent colleagues, Beth, Hale, and Emma Bartlett, who are both partners in our team. We have decided to do a short podcast to celebrate International Women's Day. So we're thinking about what's going on at the moment, where we can talk about women's rights. And of course, if you're an employment lawyer, the biggest thing on everyone's lips at the moment is the Employment Rights Act and all the changes that are going to come in with that. So it got us thinking about, well, what is the Employment Rights Act doing for women's rights? And there's quite a few changes that are coming in, staggered over this year and next year, that will directly affect women and also indirectly affect women. So we're going to talk about what those changes are and what we think the impact is going to be. So I'm going to hand over to Emma first to talk about enhanced protections against dismissal for women.
So the current provisions which came in recently gave women protection from redundancy from the point that they tell their employer that they're pregnant, and then for the 18 months after that. So that will capture ordinarily time after their return to work. And what that means in practice is that if an employer is at risk of redundancy, for example, whilst they're pregnant on maternity leave or on their return to work, that they are to be offered any suitable alternative vacancy if there is one, in preference to other people. But under the Employment Rights Act, the legislation is going further now and giving an enhanced dismissal protection for pregnant women and new mothers, in that it's to strengthen protection against dismissal, that you can only dismiss a woman who has notified you that they're pregnant or they're on maternity leave or they've returned to work over that 18-month period. This also covers people who have notified you that they're going to have a child placed with them for adoption as well. And it means that you can only dismiss in very limited circumstances, one being gross misconduct and the other being total business closure. If you do go ahead and dismiss, then it could give rise to an automatic unfair dismissal. And the government is also contemplating removing capability as one of the fair reasons to dismiss for an individual who might be at risk of dismissal during that process as well. This part of the legislation, I believe, is due to come in. The commencement is expected in 2027.
Thank you, Emma. How helpful do you think this new change is going to be in practice?
I think it should bring about some change in terms of an employer being able to take steps to remove somebody. It's quite often the case, and it's not just my view, this is talked about very widely in the media, that women who are returned from maternity leave find themselves in a redundant situation that can look non-discriminatory but can feel very discriminatory in that regard. So in the circumstances, it gives them this enhanced dismissal protection, gives them additional rights and should prevent an employer from doing this and make people think harder.
And Beth, do you have anything to add on that?
No, just that so much of this, as with so much of the Employment Rights Act 2025, a lot of it is still open for consultation. So we don't know all the details yet. And I think this is one of those areas where we don't quite know all the details, but it's certainly going to be an enhanced protection.
Yeah, it'd be interesting to see how it plays out, like with many of these changes. So moving on, so one of the key changes that's coming in is protection from harassment, and obviously this doesn't just apply to women, but as most people know, it will impact women most likely the most. So Beth, you can talk to us about what are these protections that are coming in.
Yeah, so many people know that in 2024 the government introduced a mandatory positive duty on employers to prevent sexual harassment, to take reasonable steps to prevent sexual harassment. When that legislation was going through Parliament, the original draft of it said that it was required employers to take all reasonable steps, and that word "all" was removed during its passage through Parliament, so it became just reasonable steps. That word "all" is going to be reintroduced. It has been reintroduced in the Employment Rights Act. That's likely to come into effect in October this year, so in October 2025. And so that ups that obligation. It puts an additional obligation on employers to take all reasonable steps to prevent sexual harassment. It extends that duty to sexual harassment by third parties, so that is just it gives that extra little bit of obligation on an employer to prevent sexual harassment. What the difference is between reasonable steps and all reasonable steps, again, one of those areas where we're yet to see the detail. The government have said they're going to publish regulations setting out what steps are regarded as reasonable, and it will depend to some extent from industry to industry, from employer to employer. But the key word will still be a reasonable step. The other change that's coming in is that third-party harassment. The Act is going to introduce a standalone claim for harassment by third parties, so that employers in certain circumstances will be liable for harassment committed by third parties, so people who aren't employed by them, in circumstances where the employer has not taken all reasonable steps to prevent that from happening. And that was there was a provision in respect of third-party harassment in the original version of the Equality Act that was removed in 2013. So there's been a sort of lacuna in the law since then. This is filling that gap. The third piece of this is a prohibition on non-disclosure agreements, on confidentiality provisions which prevent people from speaking out about harassment and discrimination. Again, the devil is going to be in the detail of that, because there are going to be exceptions from that prohibition, and we've yet to see what that's going to look like. But that's a really powerful tool, I think, and in many ways, in my view, will sort of change the landscape in terms of discrimination and harassment allegations, and just take confidentiality out of the conversation altogether, which is going to be a really interesting development. And there are people who are worried that it will actually be disadvantageous to women, because it will mean that things will be less likely to settle. I think that remains to be seen how that plays out, and it depends largely on what the regulations look like and the circumstances in which NDAs will be allowed. It's one final bit, my fourth aspect of preventing sexual harassment or additional protections against sexual harassment, is that the whistleblowing legislation is being changed so that sexual harassment is expressly included as a disclosure about sexual harassment is expressly included as a qualifying disclosure, which is likely to be protected under the whistleblowing legislation. And that there's an argument that was already the case, that an allegation of sexual harassment may already have satisfied the test for whistleblowing under the legislation, but this is just making that absolutely clear.
The thing that strikes me the most about these changes is it sounds great from a sort of individual perspective as a woman in the workplace. They certainly sound like really positive changes. I think the daunting aspect of this is if you're sort of the employer, you're sitting in HR thinking, well, what does this mean? What is all reasonable steps? And I think, as you say, that's very much going to depend on the consultation that comes in from the government and the guidance. And as you say, it's going to be very industry specific. So yes, be interesting to see how that progresses. And then the next change that we're going to talk about is gender equality and menopause support. Let me hand back to you, Emma, to talk about.
Yes, of course. So the Employment Rights Act is going to bring in an obligation on employers with at least 250 employees to have an equality action plan for gender equality. Most employers will probably already have that anyway, because they will have been caught up in the gender pay gap reporting. But that step is going to be voluntary from April 2026 and then mandated from the following April 2027. And the same in respect of menopause support, to have a menopause action plan. So lots of food for thought there for internal policies, particularly on menopause action plan. Again, voluntary from April 26 and then mandated from April 27.
Sounds like a long way away, but it'll come around fast. So definitely lots to consider. And then the final changes that I was going to talk about was family-friendly rights and leave. So these are now going to become a day one right. There's now no longer a qualifying period. Obviously, this won't just impact women, but will affect women the most. As you know, women are typically sort of primary caregivers. They're the ones that typically take the most leave when it comes to looking after young children. In a sort of similar vein is flexible working requests. Employers will now have to give sort of a more robust response if they're going to turn down a flexible working request. So that will obviously strengthen the position there as well. So that is some additional rights for women.
Just on that flexible working, Rachel, I think it's really the potential impact of that is really significant, because I think what the government have always said, and they said this in their Make Work Pay document before they came into power, is that what they want is flexible working to be the default rather than the exception. And I think imposing additional obligations on employers to justify why they are turning a flexible working request down, I think is a really powerful tool to do that. I think that might make it difficult for employers who don't want to accept a flexible working request, and obviously it's not necessarily backed up by sort of enforcement teeth, because the claim for failure to comply with the flexible working request rights is pretty limited, but underlying that there is it often sits alongside an indirect discrimination claim. So I think it's a pretty powerful change, that one.
Yeah, I agree.
I think obviously applies to men and women who want to work flexibly, but yeah, I think it is a really important change.
Just wanted to pick up on your statement, Rachel, about women being primary caregivers in the UK, because there are some stats on this from Carers UK from 2024. Actually, I haven't got the most recent stats today, but it does say that 59% of all unpaid carers in the UK are women, and that women in their middle age, so 45 to 64, are most likely to be balancing, it's called the sandwich generation, where they're most likely to be balancing childcare and caring for elderly relatives. So we are an ageing population, and this should be providing more support.
If men have additional rights to work flexibly, that indirectly also benefits women who may want to. Exactly. It cuts both ways, I think.
Yeah, and the same goes for paternity leave, which the rights for that are being strengthened. So whilst that is sort of directly impacting men, it's going to impact women, because of course if men can take more leave, then women can get back to work potentially.
I would say in the last 20 years we've seen a real shift away from regulations which particularly help women. Obviously we're talking today about legislation that is helping women, but the legislation now I think also helps families, which helps, as you say, indirectly helps women to be able to continue their careers where they choose to do so, and also helps in our practice. We see men saying we want to be able to do this, and it's changing that societal mindset as well. There are obviously lots of provisions under the Employment Rights Act, but there is one more provision that we wanted to talk to today in particular, which we think indirectly benefits women. Rachel.
Sure, yeah. So one of the biggest changes, arguably sort of for employment lawyers when we're talking about bringing claims, because unfair dismissal is sort of the bread and butter claim of most employment lawyers. The biggest change in the Employment Rights Act, arguably, is that the qualifying period for when you can bring an unfair dismissal claim is being reduced from 2 years. So at the moment, you need 2 years service in order to qualify for an unfair dismissal claim, and that is being reduced to 6 months. It was originally in the Labour manifesto going to be a day one right, but there was sort of a huge back and forth in the comments with that one. But the qualifying period is now going to be 6 months. And how does this impact women more than men? Arguably, well, there's statistics on this, I'm sure. Women are more likely to take up more shorter term employment. So it may be that this will impact more women than men, as they will acquire that right earlier on in their employment, and they won't have to wait 2 years. They will have that right after 6 months. I mean, it remains to be seen, but it hopefully should strengthen rights for women who are sort of more likely to be in more shorter term employment.
There's also a change, which is that the limitation period for bringing a lot of employment claims is going to be extended from 3 months to 6 months. And I think that also has an impact on everybody bringing claims, but an impact on women who, particularly in things like sexual harassment claims, where people often aren't in a state to be able to bring a claim within the very short time period of 3 months. 6 months is still short, but it gives a little bit of extra time. Can I just also be a slight voice of doom and say that I don't think it is all it's not all an improvement, because I think there are lots of additional rights in the Employment Rights Act, and of course that gives additional rights. It, in some cases, imposes additional burden on employers, but also I think what we currently are seeing in our practice is that there are huge delays in the employment tribunal system. So enforcement of these rights is really, really hard already, takes a long time, and additional rights is likely to mean that becomes even, that the employment tribunal system becomes even more stretched, and that justice is therefore delayed even further. So I think that is a problem which ought to be addressed. It doesn't seem to be being addressed at the moment.
No, you're absolutely right. The length of time, if you allowed from the start of notification to ACAS through to the point at which you've gone through the process, it could be 2 to 3 years by the time you get it. What I would hope from the new rights coming in is that there's increased awareness that there is greater protection, even if you have to wait a little bit longer if you were to go through litigation to get before a judge. But I would hope that it means that more people become aware of what their rights are, and as such feel more empowered to have proper conversations with employers at the relevant time to try and resolve the issues, rather than waiting for ACAS or litigation.
Absolutely.
Brilliant. Well, thank you both so much. It's been a really great discussion about the Employment Rights Act. And yeah, watch this space. There's going to be lots of changes coming.
Thank you for listening. If you need any more resources or interested in finding out more about CM Murray, please go to our website, www.cm-murray.com. Thank you.